you very much. Now, I think we have to move forward. Thank you very much for this. Now, our third panelist. Yes. Is a Belgian, Mr. Roger Kaiser, who's a senior policy advisor at the European Banking Federation, working specifically on tax compliance, which includes financial sanctions. And Roger will bring his presentation from the perspective of the banking sector in Europe. Thank you. You have the floor.
Thank you very much, Nicolas. Yes, indeed. I have appreciated the introduction of this panel, which you said would be a panel for lawyers, and indeed both Maya and Robert are obviously impressive lawyers. I'm not a lawyer. I'm not either working in banks operation like Martin Vogt, who made an excellent intervention yesterday. So some details in my presentation and in my comments and answers may be possibly missing. However, in my capacity as senior policy advisor at the European Banking Federation, the EBF, where I'm in charge, as you have just explained, of advocacy on tax and compliance, including AML compliance and also financial sanctions. I guess I'm a privileged observer of some policy and regulatory developments and on their impact on European banks and on all the European banking sector. So I hope that my contribution from that perspective will be useful. And so I will focus mainly on risks, although Robert has also talked a lot about risks rather than on legal aspects. So now let me try to share, if possible, my screen. I hope it works. Not sure. So the potential implications of sanctions regimes, as I have just mentioned, can be huge for global business, and particularly for financial institutions, if they are engaged in business with a sanctioned entity. And over the last decade, the fines, the monetary penalties imposed on foreign financial institutions by the Office of Foreign Assets Control of the US Department, the OFAC, have reached levels that they had never reached before. And of course, the case of the huge fine which was imposed on BNP Paribas in 2014, which to my recollection amounted approximately $9 billion US, is a striking example. Another major consequence, and if not the more important one, of non-compliance with sanction regime is the potential disconnection from the financial system of the jurisdiction imposing the sanctions, and it's particularly the case of the US financial system. So this would include the inability to produce financial services related to the US financial markets, and also to provide transactions in US dollars. Another important aspect would be that it would lead to the inability to enter into correspondent banking relationships with US banks. Inability also to manage US dollars linked funding, leading to serious problems in terms of funding, in terms of liquidity, and potentially in terms of capital adequacy. A perhaps less tangible aspect is the reputational risk, which can be also very, very important. And all this can lead to the bank's viability being endangered. So this is why banks should have or must have robust sanctions programs in place as a matter of safety and soundness. Two important aspects of these programs are the customer due diligence, or KYC in the US terminology, and the sanction screening. If you have listened yesterday to Martin Vogt, your attention has been paid to the fact that sanctions programs are much broader than just those two aspects. But I will try to remain high level here. So due diligence, I guess you all know what it means. It is a set of internal controls that enable a financial institution to establish the customer's identity and also to predict with relative certainty the types of transactions in which this customer is likely to engage, and also assess the extent to which the customer exposes the financial institution to a range of risks, from the AML risks to the sanctions risks. Sanction screening, it's extremely far-reaching, and there are many different aspects. But in a nutshell, sanction screening involves checking information about a person, an entity, goods or services against sanctions lists, so including the official lists like the SDN list from the US or FAC, and a gray list that are built in-house. So allow me to very briefly remind you of the scope of sanctions. I know it has been very much covered in detail by the other speakers who are much more knowledgeable than I'm. But I think it's important when speaking about sanctions clauses to put that into context. So the basic components of the sanction regime, there are three of them. We have an economic sanction, an economic action or restrictive measure which will restrict trade, financial transaction, diplomatic relations, or movement. This action is taken against eligible targets. We have, I would say, two kinds of targets. We have the state, officials, some classes of persons, individuals and entities, and we have then some business areas or some themes which can be targeted by the sanction regime. Then the objective is to influence, i.e. to deter, prevent, or punish the target's actions, activities, and behavior. Now, to put that in place, to implement that, there are a number of levels. We have the jurisdiction or the international organization imposing the sanction regime. We have, of course, talked a lot about the unilateral approach of the US. Then you have the jurisdiction enforcing in the sanctioned regime, which may be different from the jurisdiction imposing the sanctions. And so I move to what is of interest to us in this presentation on sanctions clauses. We have the individuals and entities which have to implement the sanctions, and in fact they are subject to the sanctions, but in a way that actually they are required to comply with the sanctions. This can be extremely broad. But of course, certain professions will be particularly, and which term should I use? Targeted, but I'm not speaking about the sanctions target. They are specifically entrusted, I would say, with this task. I will not remind you with the differences between primary sanctions and secondary sanctions here, but of course with secondary sanctions we have a very broad scope of these people who have to implement the sanctions regimes. Then, because those required to implement sanctions are still being contracted with sanctioned companies and are potentially subject to judicial and enforcement, it is very much recommended that all contracts for international trade and finance contain robust sanctions clauses, which can be grounded or should be grounded on the force majeure clause. And for example, as mentioned by Robert in the previous speech, trade associations are publishing best practices and examples for such clauses. The clause shall provide a list of presumed force majeure events that prevent or impede the affected party from performing its contractual obligations. And in this list, you should include the acts of authority and any mandatory provisions of law or regulation or order of any court of a competent jurisdiction. You can also be more specific and mention specifically sanctions regimes. The recognition of the occurrence of the force majeure event is subject to the affected party proving that the impediment is beyond its reasonable control, and the effect of this impediment could not reasonably have been avoided or overcome by the affected party. But what is more important for sanctions clauses is that the affected party must prove that the impediment could not reasonably have been foreseen at the time of the conclusion of the contract. What does this mean? It means that both parties, all the parties, at the time of the conclusion of the contract, should guarantee that they are not included in the sanctions lists, as it should also be the case of their members, management and affiliates. And they also have to guarantee that they are not and will not be associated with persons, entities included in the sanctions lists. Now, there is a formal obligation, which is the notification. So the affected party shall give notice of the event without delay to the other party. Now, what are the consequences of the sanctions clause and the exercise of this clause? Mainly two. So the clause will be evoked by one of the party, the affected party, but the consequences will apply to both parties, and they will both be relieved from their duty to perform their contractual obligations. And here there are two possible options. Either the impediment is temporary. In the case of sanctions, the performance of contractual obligations is suspended for the duration of the sanctions. So at the end, payment obligations can be reinstated. And you can also, as a second option, you can also provide for the possibility for termination of the contract. For example, at the end of a specific period of time. To my knowledge, the standard duration equals to 180 days. Second consequence of the sanctions clause and its exercise, parties are relieved from any liability in damages for improper performance of the obligation or breach of the contract in the case of a contract termination. Now, in the interpretation of contractual sanctions clauses, conflict of law are of course considered and may arise, notably as a result of the extraterritoriality of secondary sanctions. And I think previous speakers have mentioned the La Mesa case, which is now really a reference. So this case opposed La Mesa Investment Limited, which is a Cyprus company, and Synergy Bank Limited, which I think is established in the Virgin Islands, but subject to UK law. And so under the framework agreement between those two companies, Lille, so La Mesa Investment Limited, Lille, lent to the other company, to the bank, an amount of 30 million pounds, and was to make on a 6 months basis reimbursement of the principal and the interest. But what happened, and we have talked about this, Mr. Victor Vekselberg, in April 2018, Mr. Vekselberg, who is the ultimate owner of La Mesa, was included in the list of SDN under the Russia and Ukraine sanctions program of the US. And so as a result, La Mesa was subjected to the same measures. In the framework agreement, La Mesa and Synergy Bank had included a quite standard clause of force majeure, referring to any mandatory provision of law, or regulation, or order of any court of competent authority. And the question was then to be examined by the court as to whether this standard clause should be considered sufficient to oust the common law position that the English courts normally do not give effect to foreign law in order to excuse a party from the non-execution of a contract. And as we have already heard, the conclusion of the court was that the mandatory provision of law, which was referred in this clause, could not be confined to laws that require compliance, but also should include laws that may impose a penalty or a sanction. So the clause was considered sufficient. Now, we are, as financial institution, facing this fantastic blocking statute. And if I have to say only one word about that, is that the EU blocking statute only exacerbates the problems, and here the situation of how to interpret the sanctions clause. It exacerbates the situation of the conflict of law and the problems of interpretation. There are a number of law cases, but it's very it's very unclear, and there are various opinions. I'm mentioning 3 of them, and in particular the Bank Medi case, which is well known. So first, there has been a case opposing PAM International to Exact Software Netherlands. And here the Hague District Court enjoined Exact to honor its contract, considering that Exact could not invoke the force majeure. In this case, the Hague District aligned its position, I would say, on the blocking regulation. It is the contrary in the case Maman Cochet Mining Limited versus Aegis Managing Agency, where the English High Court considered that the regulation did not apply. So it's a totally different, the opposite view as in the case opposing PAM and Exact Software. In the Bank Melli case, which opposed the Bank Melli to Deutsche Telekom, my recollection is that Deutsche Telekom should reconnect the bank. But what is interesting here is that there is a statement by Advocate General Hogan, which clearly admits that EU companies are facing dilemma which are brought about by the application of two different and directly opposing legal regimes. So some concluding remarks for my very high level presentation. I'm very supportive of the comments made by my, if I may say that, my colleague from Deutsche Bank, Martin Vogt, yesterday, who insisted very much that banks' efforts in implementing sanctions regime are very substantial. And they all must have robust sanctions regime in place as a matter of safety and soundness. It's very important. And I think also Robert in the previous speech has expressed that very clearly. The sanctions aspect are part of a much broader group of obligations for banks, which have to implement a risk-based approach, and so there are a lot of consequences from this sanctions regime, and banks should be extremely careful because, as I have tried to explain in my first slide, the consequences may be very, very important and I would say dramatic. Second remark as a conclusion, all contracts for international trade and finance must contain a robust sanctions clause. Now, it doesn't mean that that there will no be any legal problems and that litigation cannot arise even if you have included in your agreement, in your contract, a very robust sanctions clause. Regrettably, the EU blocking statute only exacerbates this situation. So I'm now happy to answer your questions.